Deputy Registrar, you can call the case.
Thank you very much, Honorable Mr. Justice Witt. Caribbean Court of Justice, Appellate Jurisdiction, an appeal from the Court of Appeal of Belize. Status hearing in CCJ Appeal BZCV number 2 of 2014 between the Maya Leaders Alliance and 23 other villages and the Attorney General of Belize. Today's panel comprise their honors, Mr. Justice Witt, presiding judge.
Good afternoon.
Mr. Justice Anderson.
Good afternoon, Counsel.
And Madam Justice Rajnath Lee.
Good afternoon, Counsel, and good afternoon to everyone.
May we have the appearances, please? Thank you.
May it please your honors, Magali Marin Young, together with Alistair Jenkins for the appellants. And good afternoon as well.
Good afternoon, your honors, my learned friends. Samantha Matut Tucker on behalf of the Attorney General.
Yes, I think those are counsel. Professor Solorio is also in. Welcome, and everybody who is listening in. I think what we should do is look at what was discussed the last time on June 3rd and see, because there were several things that needed to be done. So we want to check if those things have been done or how far things are. The first issue that we discussed was the contract of the authority, Professor Solorio, and the question was that contract renewed? Has it been renewed? Ms. Matute?
If it pleases you, your honors, it is my understanding that the contract was redrafted and it has been submitted for signature by the Attorney General, and as soon as he has done so, it will be forwarded to Professor Solorio for her signature.
I see. And that is an extension for a certain time?
Yes, your honors, it will be for a further 6 months.
Okay, well, we're almost, we are far in those 6 months, I think.
Yes, your honors, as the last contract would have expired, I believe, in March.
In March. Is that your understanding too, Professor Solorio?
Yes, Your Excellency, thank you so much for allowing me to participate in this hearing. In response to your question, my first contract expired in April of 2020. I understand that the extension would expire in October of 2020. I haven't signed an extension, but I have continued performing my duties under the role in this matter as dispute resolution authority.
Okay. Under the assumption that your appointment has been renewed for another 6 months.
Exactly. I have a de facto assumption that there has been a renewal, and I also wanted to make sure that the work was completed as well.
Okay, well, we will get back to that, but thank you for this. I think we discussed on June 3rd that maybe, well, there might be some disadvantages on such a short term of 6 months, as we see that needs to be renewed every time. But apparently, the government chose to keep it at 6 months for the time being. But before we get to October, we will also need to discuss or consider a new renewal, because this, of course, this is not over yet. It takes time, as we all know. Okay, but for the time being, it seems to be all right. There was a discussion about the also. Yes, Justice Anderson.
Yes, may I inquire of the Counsel for the Government whether the 6 months could run from the date of the last signature on the contract. Is that something that could be considered?
Your Honors, I will definitely have to take that up with the Solicitor General for her guidance. As it is, my understanding is that it will be extended from the date of expiration. So it would be from March, or as Professor Solor has stated, April until I believe October to complete the year.
I understand that. I'm just, in other words, I understand it's going to be extended from the date of the expiration of the first contract. I'm just asking you to take up the issue as to whether it could be extended for 6 months from the date of the final signature on the contract as extended, so that we don't have a similar situation in a month's time.
Your Honor, as I had stated, I will need to take instructions on that, as it is the instructions now that it will be extended for the 6 months from the expiration of the previous contract.
Okay, well, but anyway, this renewal will expire somewhere in October, that's correct?
Yes, that's correct.
I think then the court would want to be informed whether there is a further extension.
Your Honors, we are in discussion, well, at least it's my instructions that there are discussions on a further or a renewal of contract.
Okay.
But there has been no concrete decision taken on that.
Okay, but as soon as that decision is taken, the court will be informed?
Yes, Your Honors.
Okay, great. Okay, then another subject which was discussed, the customary land tenure policy. The appellants stated that they were still waiting, that was in June, on the approval of the document from the Attorney General. Has there been any approval on the document granted by the Attorney General?
Your Honors, on the last occasion, we had indicated that we would have submitted the document to the policymakers, to the cabinet, and we have done so. And our instructions is that at this time, there needs to be some further discussions on it, as there are some gaps that the government believes that needs to be filled. And importantly, 2 of those gaps has to do with how it is that third-party rights will be treated in relation to the areas that have been delimited or would be demarcated as Maya lands, and also how it is that non-Maya communities that fall within Maya lands, how will those be managed?
Okay, so that is not the easiest point, probably in in this. Okay, so that is still ongoing.
Yes, Your Honors.
Good. We will get back to some of those issues later on. Then there is the demarcation methodology. We understood in June that it has been agreed upon by the parties, that the Commission believed it has jurisdiction to proceed with this project without specific approval. The Commission added at the time that the onus is on the Maya now to take the lead on this project, commence mapping. Ms. Matut-Tucker was asked whether the approval of the Attorney General is required. Anyway, that would need the answer to this question could maybe be given at the next compliance hearing, that's now. Also, the appellants stated that they have the technical equipment to commence the mapping. Appellants stated they would take 2 years to complete this process, and they were encouraged to start mapping as soon as possible. So the question is there any further specific approval necessary for the methodology by the Attorney General? Or is it that everyone understands that we can go on with things as they are? and whether the appellants have commenced the mapping process. Now, I think the mapping process is mentioned in the compliance report that we got today from the appellants. I'm not sure if everybody got that, but what I understand is that that mapping process, that is 4 phases, 3 phases have been complied with, but the implementation, the real work has been delayed somewhat, understandably, by COVID-19 situation. Is there anything to say about the demarcation methodology? Is there any further word from the Attorney General, or is it that everybody understands that we can just go on as has been started? Maybe Ms. Alamila could say something about that from the Commission.
Your Honors, at the last hearing, my understanding was that we would proceed, that we remain of the position that the Commission has the authority to declare that this is acceptable and to proceed. So we did not seek approval beyond our offices.
Okay.
Because I think we debated that at length the last time.
Yes.
And I think we concluded that that wasn't necessary.
Okay. So that is clear then. Then let me get to Ms. Young with the question where the mapping process is. Or you want to say something about the mapping?
Yes. One more thing that we have already written, the Mayas, is that the Lands and Survey Commission has asked for a meeting with them to make sure that whatever information they gather is compatible with the Lands and Surveys protocols and systems that they have in place. So that is something that we're hoping to be able to do virtually. So we want to reiterate to the appellants that this is important, because we wouldn't want them to exercise or carry out a lot of work only to find out later that it's not applicable or useful based on the system we have with the government.
Okay, Ms. Marin Jong.
Grateful, Your Honors. In terms of the mapping exercise, as we have placed in our report, which I must apologize for the lateness,
I think we will, for the next time, we will ask maybe a week before we have the hearing that you both file a report, because it's difficult to get that information at the last minute. We understand that it's not always easy, but anyway, we will arrange that properly for the next time. But
yes, we sincerely apologize to Your Honors for the lateness of that report. But I don't know if Your Honors appreciate, last week Belize was distracted with the hurricane, and so the country went into hurricane preparedness. So, but we do apologize, and we'll endeavor to file it beforehand. The appellants have secured funding from the land tenure facility, and they have commenced, but because of the COVID restrictions that have been put in place, they have had to slow down, but they have been in consultation with the communities. They have not, the present restrictions are social gatherings are limited to 10 persons, and this has placed some, has restricted them in being able to convene community meetings, to consult the community, and to get their consent in relation to the auto delimitation process. They are exploring getting the community, getting other forms of consent from the community, virtual consent or consent in writing by signatures or from community members because of the inability to convene a village for purposes of consultation and procuring the consent. The delimitation process and methodology sets out a precise manner in which the consents are to be procured and the verification of that consent. And because it was designed pre-COVID, it requires that the government be present physically to verify the consent. And I am happy to hear from Ms. Alamina that, in fact, in relation to the Lands and Survey Commission, that they're open to meeting with the stakeholders virtually, because I think the parties do have to adopt, given the restrictions, the COVID restrictions, and especially because we're dealing with indigenous communities who themselves, through their own governing processes, have implemented their own safeguards to prevent the spread of COVID in their communities. So I am, for the appellants, we're hoping that the Commission and government will be flexible to measures to work around the COVID, so that the requirement of physical verification could be done virtually, or that it be the consent be given in writing. That needs to be explored, and there may be some variation to the delimitation process and methodology because of this. So from the appellant's perspective, they're hoping to work out with the Commission and hope that the Commission and government would be flexible enough to vary that process to include virtual meetings, consent in writing, other forms of, other than what was stated in the DPM. So the appellants have completed the consultation process and auto delimitation discussions with 2 communities. San Benito Puente is one of those villages that they've completed, and Aguacate. They have completed the training of their personnel for purposes of the field work. So in terms of the mapping process, there's been some slowdown because of COVID, but the appellants and the alcaldes have been striving to find alternate means to consult with the community, and they will need to work with the Commission and government in terms of agreeing to the forms of consent and the verification of those consents, given that the community cannot physically be convened at this point. So that's a challenge right now because of the present restrictions imposed by government, and also because of the village alcalde's own restrictions within the community to prevent the spread of COVID. So that's where that's at. There's been some training. There is equipment, but I am told by the appellants that now they will have to, if there was any insistence of in-person meeting, that they would have to procure thermometers, oximeters, or other devices to try to, and protective gear if there was insistence. So, but they are hoping to work with the Commission and the government, and hope that the Commission and government will adopt and be flexible to working around what was anticipated under the DPM.
Okay. It was thought that it would take about 2 years to complete it. Is that going to be longer now, or is that still what you think? 2 years.
Your Honors, if I could, with your permission, if the court were minded to have the appellant's representative answer that question, because I don't know on the ground the target time and how COVID has affected that target time. So with your permission, if I could ask the court to have the appellant's representative answer that question.
Yes, please.
Thank you very much, Your Honors. I am Pablo Mis, the Program Director for the Maya Leaders Alliance. If I may share how we are contemplating addressing the new restrictions that has come about. Clearly, there needs to be some deviation from some of the agreements we have made in the delimitation principles and methodology. We are hoping to develop strategies that still meets the spirit of the agreements that we have, but a bit more flexible in how we go about achieving those. Of course, once we are more clear on what exactly the strategy will be, we will then be in conversation with the Commission. I know that the Joint Technical Committee that includes a representative of the Commission, the advisor of the Commission, and a representative of the Maya people on that committee. I know that they also have been having conversation on how best to move the projects forward, particularly the mapping and the legislative drafting consultations in the context of COVID. We're hoping that very soon we will be able to provide more clarity on that. This, of course, will mean that some of the activities that we anticipated would have been done quite rapidly will have to be a bit more flexible. We have already hinted to the funding agency, the land tenure facility, that we anticipate the need for an extension to the project. We are at the moment seeing an extension of at least 6 months to the project, but that does not at all stop us from trying to move ahead full force once the restrictions are lifted. As our council have indicated, we have trained all the teams that need to have been trained. They've already acquired some test practice just to sharpen their skills in the area of field data collection and also in holding meetings with communities. It's a matter of now being able to deploy those teams full force, and we're hoping that as soon as the restrictions are lifted, that we can actually deploy full force and try to at least cut down on the amount of time that we need to extend. Our aim is to try to do as much as we can within the 2 years initially that we agreed. But as I indicated, I think there is no way around the fact that we will have to extend a little bit, and we have already begun that conversation with our donors.
Okay, thank you. I see both parties see the necessity of coming together and discuss certain ways forward. So I understand, Ms. Alamia, that there will be an invitation from the Commission towards the Mayas to discuss these matters further, correct?
That's what I'm understanding, Your Honor. So I will wait. We had already requested from them to tell us what kind of adaptation approaches that they were considering and to communicate that to us when they have a better understanding of how to proceed. So, and also what we proposed was that perhaps looking at the land tenure facility project, that we look at the chronology of activities to see what other activities that perhaps don't require that level of community contact can be placed earlier in the process instead of waiting towards the end. You know, do as much work. Maybe we won't be able to totally complete them, but to at least advance them as much as possible. So we are aware of the limitations that everyone has, and we are definitely willing to listen to what they would bring forward.
Okay.
Mr. President, if I may, through you, ask Mrs. Alamiller, you mentioned the Land and Surveys Department and that a meeting is being arranged, a virtual meeting, as I understand it. Do you know how soon it would be? And do you know what, in a nutshell, may be the concerns of that department?
I don't liaise directly with the Maya leaders or the Huliancha Society, because that's an activity under the Huliancha Society project. But what I understand from my staff here is that it has already been communicated to them that the Lands and Survey is prepared to have the meeting at the convenience of the Mayas. So we're waiting for them to propose a time and a date that suits them best. Basically, what we're wanting to have assurances is that whatever they do on the ground and whatever data they collect is data that can be synergized or is complementary to the data and the standards that are used within Lands and Survey Department, because we can't very well create a new system for this, because we will be merging that information with what the GIS department has at the Ministry of Natural Resources. So it's basically to ensure that I don't understand all the technical language and all the GIS and satellite and so forth, the technical language, but apparently there are different ways in which you do GPS readings and mappings and standards that you collect. So that is one, that is the main focus of that conversation, to say for the record that this has been communicated. We have spoken about this in detail so that later on there's no conflict in saying, well, we weren't aware that this is how you wanted the information. So that is the main, that is the objective of the meeting. We have also, I was, just as a side note, Your Honors, I was a panelist for the UN high-level plenary, and I presented a very brief presentation on the delimitation and demarcation methodology. And there were very highly technical people and people from indigenous peoples who have advanced and have already identified their lands. We had the participation of NASA, of CANIOS, about 4 or 5 agencies. And what became evident to me is that there is quite advanced technology that can be made available to both the Maya people and the Government of Belize that we can tap into, and that perhaps we learn from the experiences of these other indigenous peoples so that we don't duplicate or create the same mistakes, ensuring that whatever approach is used takes into account the limitations or the aspirations of the indigenous peoples. And so we had communicated to the Mayas that this group would be willing to have a session with them to at least explore whether there is interest in getting technical support from these various agencies. I think that was communicated about 6 weeks ago. And initially they had stated that yes, that they were very much interested and that they wanted a preliminary meeting to prepare for this larger meeting. But I guess with everything that is happening, we have not heard back from them, but we have communicated to them that government will proceed with this because government also has technical limitations and that it wants to tap into what is available globally.
I would imagine that would be very useful. Thank you very much.
You're welcome.
Okay, well, I think there's goodwill on both sides to get to a system that will avoid any future disputes about demarcation. So that's a good thing. So we have to leave it to the parties to further discuss and develop a proper plan for demarcation. But we will hope that it could start soon. it will take time, as has been said. Then another issue that was discussed in June was the FPIC, if I may shorten it this way, the free and prior informed consent protocol. It was said that the Commission had completed a final draft. It was sent to the appellants. At that time, they made comments and recommendations. The Commission, through Mr. Fergus, communicated that the recommendations of the appellants were not feasible. It was agreed that alternative positions on the FPIC could be submitted to government for their final decision on which is feasible. However, before this could be done, a grievance and redress mechanism must be drafted. It was agreed that Mr. Fergus would send a draft of this mechanism to the appellants within a week, and then the appellants would have a month thereafter to submit a final draft to the Commission and to the court. Once the mechanism is finalized, this and the alternative positions on the FPIC should be submitted to government. Late August was set as the target for the submission by the Commission to the government. Well, it's clear that we didn't, we're not, at least that was not achieved. We have not received anything, so could you inform us both what the situation is about this point? The grievance and redress mechanism, was it drafted by Mr. Fergus? Anyone? Ms. Alamillo?
I don't believe that it was drafted by Mr. Fergus. The agreement was that it would be drafted by the Maya leaders or the Toledo Alcalde Association. They said that they had the expertise available to help them draft it. And so that has been drafted and incorporated into the FPIC, and that was submitted to us in early August, and we have responded to them just recently about our position in regards to both the FPIC and the grievance and redress mechanism.
Okay.
And basically, Your Honors, we believe that we have stated to them that it's very evident that we are at an impasse and continue to remain at the impasse in regards to the role of the Toledo Alcalde Association, and so that they have articulated to us why they believe that their role should be as they have proposed it. We have said to them, okay, well, if that is the case, then that is something that we need to consult with other Maya people or the wider the Maya people, because that is not the information that we have been receiving based on our conversations with people who we've been meeting with. So there's different understanding. What they are proposing is not what the Commission agrees to. We're saying, okay, we may be flawed in our understanding, but in order for us to really understand that in fact this is representative of the wider Maya people's point of view, then we need to go and consult with them. And again, this poses a problem for us because of the present COVID. If they figure out a way to have virtual consultations, then we will also have virtual consultations to discuss this and to help us have an informed position.
And is it your position that if it is supported by the Maya community in the larger sense, and then it would not be a problem for the Commission?
I don't see how it could be a problem, Your Honors. If this is what the people are saying, then I think we have to advance it forward and try to communicate that to the policymakers, that this is the wish and the will of the people.
Okay. Ms. Marin-Young.
Grateful, Your Honors. The appellants had in fact submitted their response in relation to the grievance redress mechanism. In relation to the feedback on July 29, 2020. And despite following up for a response from the Commission, only yesterday they received a response from the Commission in relation to the free, prior, and informed consent protocol. Ms. Alamia is correct to say that the sticking point here is the participation of the Toledo Alcaldes Association. The Commission is reluctant to have the Toledo Alcaldes Association be a participant in the free, prior, and informed consent. And the appellants have very good reason for insisting on the Toledo Alcaldes Association's participation because, as your honors can appreciate, and Dr. Celorio could elaborate, we are dealing with indigenous communities who may not have the necessary technical expertise. And so what the appellants are concerned about is that if we have government show up and a developer with engineers speaking very technical language to a community whose alcalde may have completed primary school, mandatory primary school, but no further, or who may not understand the technical language, who does not understand the whatever activity is to be undertaken in a community for which consent is being solicited. And so what the Toledo Alcaldes Association does is it pools resources, especially because, if your honors and Dr. Celorio could elaborate, we're dealing with indigenous communities that for the most part are subsistent farmers. So the community individually, each village individually may not have the financial resources to hire technical expertise to educate them and inform them in order for them to give their consent, in order for them to have a proper understanding of whatever project is to be undertaken. And the Toledo Alcaldes Association is comprised of all the alcaldes coming together, and together they're able to pool resources, technical expertise, and there has been a trust built. It is the governance mechanism of the Maya people. They elect alcaldes, and the alcaldes get together and form the Toledo Alcaldes Association for purposes of coming together, pooling resources. So that's a major sticking point. The Commission and government is reluctant to have the Toledo Alcaldes Association participation. And the appellants believe that with the Toledo Alcaldes Association participation, it's important for them because you're dealing with indigenous communities who may not have the wherewithal and who may not have the resources, the expertise to deal with a developer who may be able to hire very sophisticated experts who the community may not understand. These are wholly new concepts. Subsistence farming is what they're used to. They may not be used to capital intensive projects such as, for example, the exploration for oil. And so having the Toledo Alcaldes Association coming together and be part of the process would enable the communities to, there's a trust. It is comprised of all the leaders, of all the alcaldes, and together they believe that they would be able to get a better understanding, better communication as to whatever project is to be undertaken, communicated to those communities, for those communities to give free, prior, and informed consent to meet international standards and to meet the criteria set out in paragraph 4 of the consent order.
So I understand what you're saying, but is it that the commission only wants to deal with the village, with the alcalde of the village or the village council or whatever it is called? If that is the case, cannot then that council say, okay, well, we need some expert advice, and so we call the the association and ask them to assist us with the decision making, with the negotiations or whatever you want to call it. Is that not a possibility?
The challenge, as I understand it, Your Honor, is that, for example, if let's say we're dealing with the granting of forest licenses. The forest department were to give a community leader, an alcalde, 2 days notice that it will show up. The alcalde may not be able to get, and if Your Honors would appreciate, the last time, in several occasions, we've seen the communities being pressured to give their consent there and then. And so there is, to a certain extent, financial blackmail being held out by some of these developers. Well, we won't hire persons from your village if you don't consent to this project here and now. We will hire from the next village. And these pressures, the community is not able to organize itself individually. And so collectively, with the technical assistance of the association, who may not be able to show up on 2 days' notice at those meetings. So that is why the appellants believe that requiring the Toledo Alcaldes Association consent should be is important. It's if I could bring it home to the court, it's like the bar association that represents members of the legal community on various issues that affect stakeholders in the administration of justice. It's very similar with the Toledo Alcaldes Association. It's a collective body, and they're able to be, as I keep saying, pool resources. They already have the experience from dealing with other communities and other issues. And so they bring that experience, which that individual community may not have in the consultation process. So that's why it's key. The appellants feel that it's key to include the Toledo Alcaldes Association, and we don't see that in good faith why there is the need to, why there is this insistence that they not be a part of the consultative process.
Okay, Ms. Amaria, doesn't she have a point? Unmute, you have to unmute.
I think the explanation or representation made by Ms. Marin doesn't really fully represent what in fact the basis of where we diverge is. We are not saying that the Maya people cannot engage the technical or financial or human resource support of the Toledo Alcalde Association. We are saying that the community must decide on its own whether it wants to engage the Toledo Alcalde Association or it wants to engage any other technical parties or expert to give them support. And in fact, the matter in regards to notice is a very poor example, because the FPIC clearly addresses that there should be sufficient notice and sufficient notice for them. So the scenario that was presented whereby you would give them 2 days notice would become mute, because the FPIC in fact addresses it very clearly. So where we diverge completely is to saying that when a developer or government wants to engage with a community for investment purposes or any other development purposes, that in fact it goes to the community and the community decides that it wants to engage TAA, it wants to engage Toledo, it wants to engage TIDE, or it wants to engage, I don't know, any other agency that it deems has the expertise and the relationship with them that they seek in order to make an informed decision. So that is and I don't know if in fact, if that is the understanding, if what the attorney has represented is in fact the understanding of the appellants, then perhaps it is very clear that we need to clarify that with them, because that's not what we are saying. We're not saying that at all. We understand everything that Ms. Marin has proposed, that in fact it's not our intention to divide and conquer. It's not our intention to manipulate them, but the intention is for them to maintain their autonomy in decision making of how they want their community to develop.
Mrs. Alamila, has it been indicated to you, or to the commission, I should say, that there are communities which do not wish the intervention or the representation of the Toledo Alcaldes Association?
Yes, that is constantly what is being said, and I know that that is constantly the refrain we have from people, and with all due respect, because Miss and Miss Cock are here, what people really say is who elected them to represent us. And of course, there are staff to these organizations, and we understand that to be the case. But when they are saying to us what is being communicated, or what the positions that have been communicated are not representative of our views, because in many instances, the alcaldes do not go into the village to consult on all these decisions. Even though customarily, and based on what we say customarily, this is the way it's done, what people are telling us that in fact, these consultations are not happening with them, that yes, the Julian Cho Society and the MLA may well be consulting the Toledo Alcalde Association and may be consulting the individual alcaldes, but we have absolutely no assurance, or we are not at all convinced that the villagers are being consulted and that they fully understand what in fact is being agreed upon on their behalf. And that is why we're saying for the FPIC and moving forward, we have to go to the communities to have these consultations, and based on that consultation and that first discussion, then we're going, and if they so choose to tell us that their communication and their representative will be the Toledo Alcalde Association or the Julian Cho Society, then we will, of course, honor that, and that is what the FPIC states.
Okay, well, this seems well, we can probably discuss this without any end, but I think your positions are clear. It needs to be negotiated. There needs to be some outcome. If this is the sticking point, that it should certainly it should be possible to find a proper solution. We won't find a solution right now, and we have to leave that to the parties to negotiate that. If at some point you think you might get a solution, but you are somehow not reaching it, we can always look if we can assist you in reaching that solution. But for the time being, I think we should leave it to you.
On that point, Chairman, may I ask of Mrs. Young, whether, given what you said earlier, the issue may not turn on the length of time that is available to the village before a decision needs to be taken. Now, we heard earlier that the FPIC will have some time standards there, which will allow the village to consult with whomever the village thinks it wants to consult with.
Yeah.
So would the point of negotiation then not be around the question as to what is a reasonable time to allow the village to consult with the persons or entities that the village wants to consult with? Siam? Did we lose her? I don't see her on, Chairman. I don't know if we've lost her.
I think we lost her. But I'm sure we will be able to get her back. Yes, Miss Koch, you wanted to say something? Or Mr. Miss?
Good afternoon, Your Honors. Thank you for the opportunity to speak. Perhaps if I could speak to that issue, from our understanding, our humble understanding of this still yet disputed point, we strongly believe that the governance system of the Maya people as a whole, we are an organized people. We organize ourselves in an autonomous way through our traditional leaders. Each one of our villages elects 2 traditional leaders to represent them. And often in our language, it is described as the eyes, the ears, the mouth of the Maya people, carrying a position as an ambassador of the will of the people of that village. Failing to recognize then this governance system, which is the way that the Maya people have long organized themselves, is to us not good faith, because it doesn't bode well with recognizing the unique and collective organization of indigenous peoples, and in this particular case, the Maya communities. We find that the Commission continues to insist that they want to go directly to the communities. The Toledo Alcaldes Association is not standing in the way of that. In fact, we are facilitating that. That is the job of the Alcaldes Association. We organize ourselves collectively. We are in direct communication with the communities. And yes, Ms. Lisselle spoke of myself and Mr. Miss as staff members. We did not appoint ourselves. Unfortunately, the way that the Maya communities are organized is that donors like the Land Tenure Facility has to come through a registered nonprofit organization. I am the executive director of the Julian Cho Society, which is the administrator of that project. So that is part of my duties. With respect to the alcaldes, however, they are the representative authority of our people. Our humble communities have practiced and used this system, and it is poorly understood by the outside, including by the Toledo Maya Land Rights Commission. The way that communities are called, only the alcalde can convene a Maya village meeting, and the village meeting is the fundamental authority for decision making. This is a part of our customary practice and norm. It is a part of the way that we organize ourselves in a self-determined way, in an autonomous way. And if it is the wish of the Commission to be inclusive, to be respectful of indigenous systems, indigenous people's right to self-determination, inclusiveness, then it really puzzles us when we are being asked then to remove the very organizational structure of the Maya people. International law provides for all indigenous people to determine their own forms of representation. I know that the Commission has stated that this is a matter of convenience. It is not a matter of convenience. It is an indigenous people's governance system, a very recognized one, a part of the judiciary of Belize, in fact. And we asked the Commission to explain to us then, why is it really? What is the intention to remove the Toledo Alcaldes Association or any mention of it in the FPIC protocol? What is the intention to remove any mention of the Toledo Alcaldes Association, if in fact your aim is to be comprehensive, to be inclusive, and to be respectful.
Okay, let me just see if Ms. Young is back in the meantime.
I don't think so.
I don't think so either.
While we're waiting, Chairman, and I know you said we have to move on. I agree with you entirely. Yes. Could I just ask this last question? Mm-hmm. Is it possible that the TAA could say, well, you know, Village X does not consent to this particular project, or we do not believe it's suitable or appropriate for Village X to have this project, whereas the village itself would prefer to consent to the project? Is that a possibility?
We missed a little part of your question, Your Honor. Would you be able to repeat just the last part of your question?
Yes, I'm just wondering if there could be some tension between what the village wants and what the larger association wants.
Your Honor, thank you for that question. I will take the first part of it and I will ask my colleague to elaborate. The decision rests fundamentally with the community. Only the community can make a decision one way or the other on behalf of the members of their village as a collective. That is very clear to us. That has always been our position. The Toledo Alcaldes Association is an organization of the traditional leaders of all 41 of those respective communities. And therefore, the wish of the village will not be different from what is articulated by the Toledo Alcaldes Association, because the association represents what the decision of that village is. Will there be a difference in decision? No, I don't foresee that, because I do continue to reiterate that the decision is fundamentally resting with the village itself, and the alcaldes represent that decision. I will ask my colleague to elaborate.
Just to expand on that question, Your Honors, the way it is reflected in the draft document, the role of the Toledo Alcalde Association actually will not be in all consultation sessions. Say, for instance, if there is a development, a very small scale development in one community, the protocol outlines that then the developer goes directly to that community because the impact are limited to that community. However, if the impact of the development is going to be beyond one community, affecting more community, then the Alcalde Association becomes a facilitating entity to establish a common platform for dialogue, for engagement, for pooling of resources. That's how it has always worked already, and that is basically what is being reiterated in the protocol there. The absence of any mention of that role that the TEA plays, though, will always work against the Maya people. If there is an elimination of the mention of their own system there, then they will always be placed against the community as not belonging in those processes. But the impact would be that the communities will not have the support to be properly informed, to have the resources that they may need to take a position. Now, a decision could be taken by communities that the leadership of the association may not agree with, but the will of the people will have to prevail. But at least knowing well that the association did its obligation, and that is to provide the necessary support, information for the communities to be able to take the decision that they take. That is how essentially it would work, and it has always worked. What we see right now, for instance, is if a developer goes into a community that has an impact beyond that community, and if the TAA, the Alcalde Association, comes along uninvited by the developer, then there is always this labeling that the TEA should not belong there, and it creates confusion in the process. So we agree that the communities eventually ultimately they hold the authority to make decisions. They also hold the authority to decide who they may want to invite. They don't only have to invite the Alcalde Association, but the Alcalde Association exists with a mandate to be there to provide those support. A community may say, we would like this other entity to provide support for us, and that has happened in the past. And then some of those entities, though, they eventually die out. So they come back to the community comes back to the association. The organizing platform of the Maya people is the Alcalde Association. It has been there and it will always be there, and its mandate is very pure, and that is to provide the necessary support it can to protect the future of the Maya people.
Thank you.
Thank you. Ms. Young, welcome back.
Yes. Apologies, Your Honors. We had a short power failure here at the office, but we're back up.
Yeah, so in the meantime, we heard from Ms. Kopka, Miss how, in their view, things work, so they gave us some more information. I think, when you listen to both sides, and it can be appreciated, then there must be a way where you can find a solution for this problem, as long as it is clear what everybody's responsibility exactly is, etc. So I think parties, if this is the last really big sticking point, should be able to solve this issue. And but I said once more, if you think that you could solve it but somehow doesn't reach a solution, and if that is the only point that's still sticking, then at some point in time we could see if we could help you reaching that decision, as to be very, very sure this monitoring system that we developed is, of course, not a system where we can order things, etc. So we are in a special kind of procedure, which is does not allow us to order anything, but we can help you, assist you if we can, to get the solutions, and also to keep our finger on the pulse, so to speak, to see how things go. And up to now, I do think that, although it's very slow, but we have progress still. So I think we should keep that going. So this is an issue I think could be solved when I hear both parties. There are points that make sense on both sides, and it should be possible to reach some form of agreement here. So let's see if you can get to that point. If not, let's see if we can assist. So that is the FPIC situation. By the way, in your compliance report, you suggest that the next compliance hearing could be scheduled for January 21st, because by then you think you will have you will be ready to finalize an FPIC protocol. So that would be a very good thing. I still think that you can get there before that date. So I would, on behalf of my colleagues, encourage you really to make an effort to get agreement on this point. Maybe it's a matter of give and take here and there, and maybe it is a matter of describing exactly the role, for example, of the Maya leaders, the association, the TEA, in this, exactly, so that there can be no mistake about that role. If you want to have that in the protocol, that is a possibility. I think both sides recognize that there are some points that that are valuable to look at. So then let me see, there was one other issue, at least coming from our June meeting, the issuance of land titles by alcaldes. There was a kind of accusation or a rumor or whatever it was, that the alcaldes or some alcaldes were issuing land titles, and of course they are not vested with this authority. The appellant said at the time, well, we just hear this, we didn't have time to investigate this, and you promised to investigate it because this would not be correct. Was there any investigation? Was there anything about it, Ms. Young? And then I will get to Ms. Amaria.
Your Honors, I will have to ask the court permission to have the Maya Leaders Alliance representative address the court in relation to that investigation, Your Honors.
Okay.
So may I have your permission? Grateful.
Sure.
Thank you very much. We did follow up on the accusation that was made. Unfortunately, we weren't able to get any specific name or information as to where exactly it was happening and the nature of it. We did ask alcaldes if they were aware of any issuing of land title by alcaldes, and as we weren't able to find any information as such happening in any of the communities.
Okay. But if that would have been the case, then you would be strongly objecting to that. Correct?
Absolutely, Your Honor. That is not a part of our process. We are very committed to the process that we have begun and that we're engaged in currently for the implementation. There is a clear outlined process for titling of lands through the delimitation principles and methodology. We have a lot of respect for this process. We have asked our alcaldes. None of them have confirmed participating in any such activity. So unless evidence can be provided of such where those allegations are coming from, we cannot corroborate that. We do not have any evidence of such. And again, we have advised all our alcaldes that while it is taking a long time, we are committed to due process. We are committed to seeing that in the end, everybody is happy and content with the process that we have engaged. Thank you.
Thank you. Ms. Amaria. Could you unmute? Because
sorry, I muted. I turned it off instead of turning it on. I think it's very hard for people to give you evidence of it because once you live in a community, there are consequences for speaking out against it, your leaders who have in fact the authority to distribute land or resources or to, so that is something very difficult. In the case we know most recently, in the case of Indian Creek Village, that in fact the alcalde and the village council have had meetings whereby they are telling people that they can issue them 20 acres of land and that in fact they can plant their farm on this private land. And in fact, the farming is happening, and this is new and recent farming that is occurring on those lands because they have been made to believe that those lands are their lands and that those lands have already been recovered by the share matter of the consent order. And that is an ongoing challenge that the present landowner is facing with that particular parcel of land, and that is just representative of what is happening in other parts of the village. And perhaps what can happen in that case is that you can in fact collect satellite imagery to show that in fact, since this consent order has come into effect, what has transpired on that land during that period to demonstrate that in fact this is not hearsay. I don't know if that is necessary, but I think it is important. I'm aware that the My Leaders Alliance and the Toledo Alcalde Association have had meetings in that village, and that following up the visit from Mr. Lorio, that in fact they went back and reported, and somehow I don't know where they're getting this understanding, but that is the understanding that they're getting, and this remains a concern because I just think that people are investing significant effort and resources on lands that they have no assurances will fall within their particular village, and on lands that in fact will be recovered, as is their hope, through the entire process. So, you know, these people, as said earlier, some of them, in regards to the most subsistence farmers, this is in fact a difficulty because these people don't have a lot of resources. If they start working a piece of land because they've been led to believe by their alcalde that in fact that is their land and that they can have use and enjoyment of that land, which is right now private land, then in fact you're really setting them up. In one instance in Indian Creek, there's more than subsistence farming happening in that parcel of land. There are big acreage of lands being farmed and converted to corn.
Okay, well, that's a concrete place, Indian Creek. Could you react?
Thank you for the opportunity to respond and perhaps to clarify. I am personally very aware of the situation in Indian Creek. If you were to visit Indian Creek, and in fact, Professor Solorio was there, perhaps a quarter, if not almost half of the village is in an area where they have well-established homes that is claimed by a third-party individual. So if that is the area that is being said as being taken away by the communities, the community members of Indian Creek have always been in those areas. They also have been using lands in and around that area, but they've been doing that for many, many years, and mostly this is just for their cornfields, their subsistence production. I can tell you affirmatively, though, that they are against, in fact, the clear cutting of that area, because as they submitted in their report to the authority, they are afraid that that land is going to be converted for what they have heard as banana plantation. So that magnitude of clearing is not happening, and there is ongoing use of the lands in and around those areas for customary practices, but those did not just start yesterday or after the authorities' visit. Those are ongoing activities. A similar situation is happening in Dolores village, where that entire area is claimed by a third party. And communities need to live, they need to provide, and they've been using and utilizing those lands for customary processes or practices. But that is not necessarily the alcalde going out of his way, or the MLA or the TA coming to say, go and clear the land. That's not what is happening. In our discussions with the communities on this very topic, what we were told is that the only persons that they know that are issuing out letters of endorsement and recommendation for land titling and parceling are the area representatives, the caretaker, and in fact some documentation of those have been filed with the authority. The latest incident, for instance, in one of our villages, San Marcos, precipitated as a result of ongoing leasing and parceling of those land by the government. that village in particular, San Marcos, had filed a report to the authority when they observed the parceling of land with a purported claim that the Commissioner of Lands and Survey have given permission. In the eastern part of the village, land was being parceled. A few weeks after that, the western part of the village began seeing parceling. That led a group of young people to organize and say, look, if I cannot get a piece of land through our process, we are going to parcel that area. Of course, the leaders eventually had to step in and told the young people that that is not the process of land distribution in the community. There is a written instruction to those young people to calm down their frustration, to try to see that that they follow due process in the community. Even if the land was being distributed for customary use, there is a process in the community that needs to be followed. But all of these, Your Honors, are the result of this lack of application, essentially, of paragraph 4 of the consent order. So those are our comments in response to some of those allegations that are being made.
Okay, well, we will get to that point further. I think we have to leave it at this, but it is clear, at least it is clear to everybody that alcaldes do not have any authority to give out land title, to issue land titles. And what you are saying is, well, that is not what they are doing. Good.
But they also have no authority to issue lands within what is now privately held lands. Even if they claim it under customary, that it's their land, even if it's land that they eventually aim to claim as their land, that as the land is presently held, it is private land.
Yes, well, those are more complicated issues, of course.
Chairman, I think that Professor Cesario was trying to get your attention. I'm not sure.
I think I was about to say that. So, Professor.
Your Honors, thank you for the space. I just wanted to clarify that I adopted 8 reports on 8 different matters. One of them was related to Indian Creek, and many of the reports shared in common problems related to conflicting land claims. In some instances, we're talking about private lands, and other instances, we're talking about lands that there's both private interests involved, but there's also use and enjoyment of the Maya peoples as well. And one of the points of concern was problems with access to forms of livelihood by the Maya peoples as well. So I just wanted to clarify that the objective of the 8 reports before you wasn't to define or decide on those conflicting land claims. I'm very aware that there is going to be a demarcation and delimitation process in which those decisions are going to be made. The objective of the reports was basically to preserve the status quo and the value and use and enjoyment of those lands, while the actual land titling claims are decided through a demarcation and delimitation process. So I just wanted to make sure that was clear to Your Excellencies, that the objective of the report, of my reports particularly, were not to decide on land claims or to give authority to grant land claims where the authority is not there. Just wanted to make sure that was clear for Your Excellencies.
I think I understood that, Professor. I wanted to ask you though, when you indicate that lands were being used and enjoyed by the Mayan people, was there any evaluation as to whether that use and enjoyment predated the consent order of 2015 or came after that consent order? Was there any factual evaluation on that point?
Historical. Basically historical. You have claims, for example, just one good example of this is the Dolores report, that you have, you basically have a community that has historically used and enjoyed these lands. At the same time, a part of these lands, or most of these lands, are considered private lands as part of the Dolores state. So it does predate the CCJ consent order, and that's precisely where the complexity lies. And that's why I think, in my humble opinion, I think it's very important that the demarcation and the limitation process moves forward very quickly, because there's a lot of conflicting claims in this area, as you know, and there also continues to be the granting of concessions and authorizations without proper consultation procedures, and a lot of these concessions are being granted on what's recognized by the law as private lands, but as your excellencies know, the rights of the Maya and their customary land rights really are beyond those recognized by the state, but on practical terms, it does pose a lot of challenges for the government as well. So that's why I think it's very important to have this delimitation and demarcation process happen as soon as possible. In terms of I think it was limited when it came to defining those land claims. I'm sorry, I'm available for questions.
No, that's all right. Professor Solorio, I just wanted to ask you, because I think we have gone after, we've sort of arrived at a very difficult position here, because there are people who may wish to have their rights to their private lands, and then we have a recognition by the consent order of the Mayan customary land tenure. And I just wondered, in your studies and so on internationally, are there best practices as to how those private owners could be, just some ideas as how they could be dealt with, so people don't think that is a matter of winner take all?
There's actually mechanisms that have been established in different countries in which you do have conversations between these third parties and government entities and the indigenous peoples involved. There's different mechanisms, actually, aside from restitution of land. You know, we're talking about indemnization. I mean, there's a lot of different kinds of alternatives, but I think this particular stage, from what I've seen from the Maya Belize situation, is that I think there's a really good opportunity here to do something of significance, to really comply with the CCJ consent order and with basically all the international law standards that we have applicable to this situation. But I do think we need a mechanism to address the situation with the third parties and the private land interests. And what I found encouraging in my studies is I did find a lot of challenges, of course, and these are noted in the reports, but I think the government is open. You know, I think the government is very open. I think the government understands, you know, the need to identify an appropriate mechanism to resolve these conflicting land claims and to deal and address with the private or third party interests in this context, despite you know, the conflicting claims and the complexity that we have. So I just wanted to communicate that to your excellencies, that there's difficulty, but I do think that there's a very important opportunity here to actually be able to identify ways to respond to this problem during the demarcation and the limitation process.
Yes, what I also took from these reports was that for example, in the forest department, people seem to be serious about this, but not knowing exactly how to deal with all these issues. That's why you recommend training and so forth. But I did see a lot of goodwill. There were some licenses which actually were not signed because the department was thinking, okay, well, we need some proper form of consultation, etc. I saw some reports where, according to the complaint, there was land leased, surveying was taking place, but then when you inquired, the government said there are no authorizations. I'm not sure what the government, maybe Ms. Matut will be able to say, tell us what the government is doing with that kind of cases. So apparently people are surveying, and then at least in the government departments there's no record of an authorization for all of that. So that those things need to be addressed. But what you would see is that people in the government, in the departments, are willing to think in this direction, but it's new for everybody. It's new for the Maya communities. It's new for the civil servants dealing with these issues too. So that and we understand that is not an easy thing to do. But for example, I also understand that with private land, there is a Private Conservation Act, which requires you to ask for a permit when you want to do logging in your private land. So there is already an intrusion, so to speak, from the government in your right to own property rights. Question: Can that kind of authority be used to reach some maybe agreement between the Maya village and the owner of the private land and the government? That's just a question. As I'm saying, we are not in a position to order anything. We're certainly not in a position to decide legal issues here. Those would be for litigation, and that will come to us, so we cannot prejudge, certainly not without knowing all the details, these kind of issues. But it would seem to us, when we're looking through the reports, that on a practical level, things could be done to improve the situation. Is that your impression too, Professor Solorio?
I actually am very hopeful, even though I've seen a lot of challenges, and this is a very difficult context, and with a very difficult and intricate history. I am very encouraged by some of the things that I've seen. One thing, for example, just to give you an example, I think that the fact that the parties are negotiating an FPEC protocol is something that could be very groundbreaking in the region, not only in Belize. And at the end of the day, I'm really hopeful that they can reach agreement on their impasse, because at the end of the day, there's a lot of components of the FPEC protocol that they're in agreement with. And I think it would be absolutely so useful to have one document in which there's a common understanding of what a consultation and consent procedure should look like in light of international standards, but also national laws as well. And I'm hoping that this process actually moves quickly, because I think a lot of the problems that we're seeing, or at least that I saw in cases like U.S. Capitol, for example, which involves more than one village, et cetera, is contradictory understandings of what the right to consultation should look like on the ground. And at the end of the day, I think having that guidance is very important. I do think having protocols too is very important of how to comply with the CCJ consent order, steps that should be taken, for example, before a concession and authorization is granted. Regardless of how we decide where the lands go and what we do with the third-party interests, I think we have more control at this particular stage and not granting those concessions and authorizations without a proper consultation process. And one thing that I did find encouraging is that there were a number, like you say, Forest Department instances in which they issued cease and desist orders when they noticed that there wasn't an appropriate consultation process, which I found very encouraging. And even though the consultation processes that I saw in the reports were not perfect, at least they had some indicia that they had promised and that they could be completed in a positive way. Another good example is the Medina Bank case.
I was about to ask you about that. Yes.
When I visited the Medina Bank village, they talked to me about Mr. Garrow Flowers, who's one of the third parties. And Mr. Garrow Flowers has reached out to the village, and he's really trying to reach an agreement with the village in terms of benefits that they should derive from his economic activities. And one thing that the village told me, something that I will always remember, the alcalde told me, we're new at negotiating these agreements. We really need this help and guidance in negotiating these agreements. And we're hoping that we can actually record in some way the benefits that we can get from this agreement. So it does also go to show that, making sure that those agreements are in writing is very important, but also that some third parties can be negotiated with. We have some third parties that are very difficult, and you see that in the report, some third parties that have committed acts of harassment and violence, and that's a very big concern to me. But there's also other third parties that are trying to engage as well. So I did find that positive. But again, I think having that FPIC protocol is extremely important to put in there. We need written agreements, recording the agreements and the benefits, that the villages are going to derive from this particular economic activity. And I just want to highlight also the importance of legal advice. I mean, the reality is that at the end of the day, indigenous villages are in a disadvantageous position. I visited the villages, and it was very evident when I visited them that this was something that they were concerned about. And I do think that the legal assistance, the time frame, organizations like the Toledo Alcaldes Association have a very close relationship with the villages, and they perceive them as part of those self-governance structures. And I think it's very important to respect all of this, because these are elements that could perhaps help in equalizing the parties in some ways when it comes to these consultation processes as well. And another thing I wanted to highlight with Your Excellencies, and I think the government is aware of this in some ways, that one discovery that I had during the process was concerns for the environment. The reality is that in many of the reports, many of the concerns were related to, of course, this impact on use and enjoyment of Maya lands, but there was also concern over damage to the environment. And the reality is that environmental impact assessments are very important. This is something where international law has been moving very assertively towards, especially in the past 10 years. And especially when we're dealing with cases like U.S. Capitol, that you have more than, you have 10 villages involved, and you have petroleum activities, and you really have a potential for damage to the environment. It's very important that none of these activities start before an environmental impact assessment is completed, and this is shared with the Maya communities as well. I know the government understands that there needs to be an environmental impact assessment in this particular case. I hope, and I reflected that in the report, that it's extremely important that the Maya communities receive ample opportunity to discuss this environmental impact assessment report, to express their concerns, and to obtain the appropriate advice that they need to be able to have more confidence in this process and to really feel more engaged in this consultation process as well. Environment was one of the issues that I was very concerned about. Lots of damage to lands and trees and rivers from these concessions, so aside from the whole, whether they're private lands or not, there are instances in which these loggings and concessions and authorizations are damaging the environment. And that's something that under international law, there's a duty to protect the environment from environmental degradation. So that's one of the reasons why it was also important to issue these reports, to make sure that there's no interference or damage or harm to the environment before these land claims are defined ultimately in the delimitation and demarcation process,
Yeah. Thank you. There was a question about, and we saw that after the report, or at the end of the report, there are the comments presented by both the state of Belize and the Maya representatives, and they were wondering, okay, well, is there a final report after that, or you just you produce your report and then you allow them to comment, but leave it at that?
Yes, and the idea, Your Honor, is to preserve objectiveness in this process, and to make sure that basically that my commentary and that my statements in the report balance both views. I didn't want any party to feel that I took into account more what one party said over the other, because I'm supposed to be an objective figure. And I wanted to make sure also that the parties knew what they were reacting to, what was important to them, so that they had grounds for discussion later. And I just hope the reports are useful in some way. I am hopeful for the process, even though it is a complicated context. And I do think your honors for being involved in this process. I think it has made a great difference. And one thing that I wanted to also tell you, Your Honors, that for me was fantastic to see is that everyone I've spoken to in Belize in this context is aware of the CCJ consent order and is aware of the need to implement it. And there's something to be said about that. I've traveled all over the Americas in my career as a human rights lawyer, and this is probably one of the countries where I've seen the most awareness of an international court judgment in my life. I've been to many countries where there's many international judgments and they're just not known at all. And one thing that you see in this context is that everywhere I went, every government official I spoke to, every Maya representative I spoke to, when I went to the villages, everybody was very aware of the CCJ consent order, but we need to take steps to make sure that it's properly implemented, that there's more guidance, that there's more protocols, and that we can really move forward with that very important delimitation and demarcation process and that mechanism for resolving third-party claims, which I'm sure will be very complicated, but it's something that's needed in this particular context if we want to make sure that we fully guarantee the rights of the Maya in this situation.
Okay. My last question is about, okay, well, you dealt with all the complaints that have come in up to March, I think. And since then, have you received other complaints?
I haven't received any more complaints. The last complaints that I received were for the villages of Laguna and San Marcos, and I was able to issue reports on both of these. And but I haven't received any additional complaints after those 8 complaints. I'm also happy to report that both parties submitted additional information on these matters, which I thought was also something very useful. And I'm really thankful to the parties for that they collaborated with my request for information and in the process in general.
Well, I think the court, I can say on behalf of the court that we thank you for a very thorough work. And of course, there will always be things that people will disagree about. But I think you did, if I may say, an excellent job in dealing with these complaints. It was very thoroughly done. And this brings me to Ms. Matute, because of course these are recommendations. We always said that whatever the authority decides, it will not be, of course, something like an order of the court. On the other hand, it cannot be something that is just words. And there are concrete recommendations from the comments that you have given on the reports. We understand that the government might have some difficulties with certain issues, but nevertheless, we have to suppose that the government is going to comply in principle with the recommendations. So the question is there some timeline in which you are going to do certain things as far as the government is concerned? We cannot just leave it at this. Something has to happen.
Your Honors, we have shared the reports with the respective departments so that they are aware of the recommendations that have been made. As it is now, we'd have to meet and discuss how it is that we will seek to achieve the recommendations. So at this point, I do not have a specific timeline within which to say that we will comply. I mean, considering COVID and trying to get everyone together in order for us to discuss how it is that we will deal with the recommendations, that poses a little difficulty for us in concretely setting out a deadline that we will comply by then.
Well, of course, you understand that the court would be interested to hear at some point what the government is going to do. We understand that you do not agree with everything, but there are certainly a lot of things that you would agree with, and that is a matter of how to organize it and how to do it. There are issues, for example, in the reports, and I'm not going into all the details, but there are issues about surveyors. People are saying, oh, I'm leasing 275 acres, and then when the authority inquires, the government says, no, there is no authorization for that at all. Now, it is a fact that these people are surveying and maybe are claiming land. If they do that without any authorization, then one would expect that the government says, okay, we have to do something about that. We cannot tolerate that, because clearly that would fall under the Article 4 order. So there are a lot of practical things. I was mentioning, for example, okay, private land, fine. Probably depends on the situation, how it is. But when we talk about logging, for example, the permit is still needed even in your own land. I think it probably has environmental consequences. It will have effects on the lives of Maya villages in the neighborhood, etc. So the government has has some mechanisms and tools to be active in this area, as the government is required to do under Article 4. Now, also we heard Professor Solorio say, well, this is, of course, has nothing to do with who has the better rights, because that will be clear once the whole demarcation process is done. And we will know more about the status of those private rights, depends on what kind of rights, etc., etc. But it is about preserving the situation as much as we can before we get to that final decision on these rights, etc., and how they relate to each other. So it would seem that these reports give a lot of food for thought, not only food for thought, but also there's a lot in it what could be done. And we understand that not everything can be done right away and all of that. We are very much aware of that, but we also think that progress, certainly on the basis of these reports, progress could be made, as we are making all the time. It goes step by step, but nevertheless, we think that we can still be hopeful that we are getting somewhere. And I think also that the fact that we have the authority now, and that Maya people and villages can file a complaint, is a good thing. Now, what strikes us too is in the reports, and that we see this, that we read about complaints made by the villages to certain departments, and that in many cases those correspondences cannot be found in the records. And I was just wondering, it should be possible to invent something very practical where those complaints cannot get lost. For example, if the village, just an idea, if the village files a complaint with the forest department, for example, I don't know what Professor Solorio thinks about that, but could they also copy the authority? You will not have to work on that yet, but at least knows there is something cooking, something going on, and could inquire maybe with the department, did you get that? At least that would be a system where you wouldn't lose those complaints, and some action could be taken quickly. Professor Solorio, is that an idea?
Your Honor, I fully agree with you. I think one of the areas of concern when I was developing the reports is the amount of correspondence that the Maya peoples had sent to the government pertaining to the different matters of expressing concerns. And much of this correspondence hasn't been responded to. And I do think there's a need for a mechanism to alert government authorities and to promote that government authorities to respond to these concerns. I think this was particularly serious in the matter of U.S. Capitol, for example, that is 10 villages. And it's very evident from the villages' communications that they're not very happy, or at least they don't have the confidence in this process. You know, they saw a lot of problems in the consultation process. And unfortunately, you can see that most of this correspondence wasn't responded to, and the consultation meetings continued. It was kind of two parallel processes, right? So at the end of the day, I do think it's important to have a mechanism to make sure that the concerns, are received by the government authorities and are responded to by the government authorities. I would definitely be happy to help in this process, of course. And but I do think, at least for me, it was an area of concern that there were a lot of communications and they just weren't responded to for different reasons.
Yeah, well, I wouldn't expect you to react on that in the sense that you investigated, but if it comes to you, at least you can inquire with the government if they received it. And that is not an official complaint for you to deal with yet, but something like that to ensure that these complaints don't go astray, so to speak. And you would not mind if that happened?
No, that would be okay. And I think it would be part of the mandate as well.
Yes.
So I think that would be perfectly, it's reasonable. It's a reasonable way for the mandate to act, if you ask me.
Okay, great, thank you.
Thank you.
Yes, Ms. Matut Tucker. So, okay, well, the government departments are aware of the report, and we now have to hear from the government what concrete steps they are going to take. Could we have an idea when you could inform us about that?
Your Honor, I would say, I don't know if it is that the court has agreed to the proposed next compliant date as being January 2021.
Would you agree with that?
Your Honors, we wouldn't have any difficulty with agreeing with that so long as everyone else is available on that day.
Yeah, sure. Well, we have to decide on a day. So the 21st of January is the day. Then we would ask you to send in your compliance reports or whatever reports a week in advance. So not later than the 14th of January. But I think we would want to hear from the government a little earlier than that, how they wish to respond on the report, what they want to do, what they are willing to do.
Your Honor, we are guided by the court, so if it is that the court wishes to hear from us sooner, then we will act accordingly in an effort to...
Okay, well, let me look at my colleagues. A month, would that be... Justice Anderson, Justice Ratchnatli?
Yes, a month is fine, Chairman.
Yeah? Okay, so if you could...
Fine with me, Chairman.
Great. So if you could inform us in writing just what the government intends to do as a follow-up on the reports, that would give some clarity. And then, okay, then the FPIC protocol, that is a big one. The demarcation is also a big one, but that is going to take, as we know, some time and maybe longer than we hoped because of the COVID situation. But parties are talking to each other to make sure that we don't create any possible disputes later on the demarcation. So that will take some time, but the FPIC protocol could be could be ready around the 21st of January. And maybe the parties could inform us a little earlier than that, what the status is, because as we understand it, there is one big sticking issue, which we think you should be able to solve. So maybe around the 1st of December, parties could tell us how far you are. I think that will give you another 3 months, about almost 3 months, to negotiate that point. And if you think that you can reach a solution but you haven't, we can always look at that when we hear you in January. But I think you should be able to find a proper solution. So those are the issues that I think I wanted to discuss. Now, Ms. Young, were there any other things that needed to be discussed? I think we covered everything.
Indeed, Your Honors, and again, grateful for the court for these report sessions. It provides impetus for the parties to get going with this process. So we are grateful for the continued supervision. And we hope that by 1st December, we can report positively on the FPIC.
Yes.
And the mapping exercise, we're hoping that there will be some flexibility in terms of the delimitation methods and principles and methods going forward with that in light of the constraints of COVID.
Yes, well, we also hope so. But as I said, we have come a long way already. We are not there, but the parties have come a long way. I think there's goodwill on all sides. It's not the easiest thing to do, which is one of the reasons why we organized this monitoring, kind of unique monitoring system. But as long as it works, it's good, because in the end you want to achieve what the order wants everybody to do. That's one thing to give an order. It's certainly another thing to implement everything properly in a way that most people can live with it. Yes, so by the 1st of December, we will hear from both parties about the FPIC situation in a month's time, so that would be, this is now the 8th, so the 8th of October. I'm not sure what day is that. Is that a weekend or a day during the week? 8th of October?
Thursday.
Thursday. Okay, well, Thursday is a good day. So 8th of October, we will hear from the government, not later than the 8th of October, in what way and how, and according to what time frame they wish to implement the recommendations of the authority. And in the meantime, it is also clear, Ms. Kok and Mr. Miss, that you could inform the villages that whenever they have correspondence with about issues like we have found in the reports, they will, of course, not first go to the authority. They will go to the departments of the government that deal with the issues, but they are allowed to send a copy to the authority, so that there is an extra check that their correspondence will be received. I think that is a good thing, because sometimes it is necessary that the government reacts quickly. So that is an extra practical measure that could be done. Ms. Alamilla?
Your Honors, I have 3 dates noted in my notebook here. I have October 8th, which you're saying is the date by which Ms. Matute is supposed to respond as to what we will do in regards to the recommendations from the authority, but I have December 1st too, but I don't know what we're supposed to do December 1st.
December 1st is you will report about the situation around the FPIC protocol.
Okay.
So, so if you that's about 3 months from now. So if you're not able to reach an agreement on that sticking point, you will report us both, so that we will have that information long before we will hear you again, and then we can decide if there is any way of guiding you or helping you to reach the agreement. That is as far as it goes.
Okay, and then we have January 21st to reconvene, have an appearance in front.
Yes. And you have the 14th of January, which is the ultimate date that you will provide us with a report.
I'm sorry.
The 14th.
January 14th will be what?
By the latest that you send in a compliance report.
Okay.
So that's 4 dates.
Okay. Just for the court to be aware, Your Honors, I guess you may know that Belize is going to have elections sometimes between now and January 21st. So considering that my position is a political appointment, I don't know, and there'll be some transition at some point during that period. I just wanted to alert the court about that situation.
Yeah, well, thank you very much. That is not really the first thing on our minds, but I understand that might have practical consequences. We'll just wait and see how that goes. But anyway, as far as it is now, I think we have a clear schedule for everybody. Professor Solorio, I thought I saw your hand, but if there's anything you want to say?
No, I just wanted to thank you, Your Honors, for the opportunity, and I also want to thank the parties for all the collaboration. And it's great to be able to support this process. It's an honor.
Thank you. Okay, so I think that is everything, Ms.
I think yes, Mr. Chairman. I believe Ms. Matute Tucker wished to say something. I see her.
Yeah, I'm going to make a round.
Oh, okay. I see. Thank you, Mr. Chairman.
Yeah, Ms. Young, anything to add?
Nothing further to add. Thank you again, Your Honors. Thank you, Dr. Solorio, as well, and Council and the Commission's participation.
Okay. Let me first go to Ms. Koch and Mr. Miss, if they want to say anything, and then I get to Ms. Matute.
Just thank you very much for the opportunity to share and to provide this space for us to really look at how we could have meaningful progress. We're very, very happy that we're inching our way towards the full and effective implementation of the Maya people's rights. Thank you for continuing to be a part of the process, and please stay safe through this pandemic. Thank you very much.
Thank you. Ms.
Thank
Matute.
you.
Thank you, Your Honor. I just wanted to add, in light of the suggestion made to copy Professor Solorio in letters that are sent to the respective ministries and departments, I was wondering too if it would be ideal to have the Office of the Attorney General added in that email so as to ensure that there is compliance or at least response to the respective correspondence. I mean, as it is now, we do have a point person that gathers information from the respective ministries and departments that Professor Solorio requests. So as to further the process.
Sure. So do you have a name or an email address or whatever, because people need to know where to send things to.
Yes, Your Honor. It's Giovanni. It's GIOVANNI Tillet, TILLETT @agm.gov.bz.
Okay, great. Yeah, I think that is useful. It's good to know that when you send something like this, serious like this, to a department, if it is, and that it has been shown that for whatever reason this correspondence doesn't arrive where it should arrive, then if there are others who will get it too, that's a good way, a very practical and simple way to ensure that it will get there where it needs to go. So, Ms. Kok, you can tell your people that whenever they have these kind of complaints, they can copy the authority and Mr. Giovanni Tellet of the AG's office to into that complaint. So we have many ways to make sure that it will get where it needs to go. Good. I think I see a hand of Ms. Alamia, or?
No, I don't. I'm sorry, I don't need to say anything else.
Okay. Okay, well, thank you very much. My colleagues and I are of course, very content that we were able to discuss all these issues with you, and we hope to see you on the 21st. We hope to see all of you, Ms. Alamia. I don't know if that is possible, but anyway, we hope to see all of you on the 21st of January next year at, now we have to look at the time because we haven't decided that. 11 o'clock for us would be 9 o'clock for you. Is that okay?
Yeah.
Then I think looking at my colleagues, 11 o'clock would be fine. So 21st of January 2021 at 11 o'clock a.m. Thank you all.
Thank you.
Thank you.
Thank you.
Thank you all.